Hey everyone, I'm Jessica Kramer with MRC-TV. Today we're speaking with Heritage's legal fellow, Giancarlo Canaparo, to discuss why some Michigan Catholic schools are suing Governor Gretchen Whitmer in federal court for closing in-person instruction. Giancarlo, thanks for joining.
Thanks for having me.
Now, obviously, enrollment for Catholic schools has gone up since public school districts are closing due to COVID. But in Michigan, even private schools have been forced to close. Can you tell us a little bit more about this case?
Yeah, sure. So what Gretchen Whitmer has done is basically closed all schools in the state, religious, private, public, you name it. And this raises a problem because the First Amendment guarantees the right to religious exercise, which includes the right to go to a religious school should you choose. Now, recently, in a case a couple weeks ago, the Supreme Court struck down New York's COVID restrictions on churches. Because you'll recall they discriminated against churches by putting more stringent restrictions on them than on secular businesses. So the argument goes in this case that Michigan schools, religious schools, are subject to harsher penalties, that is shutdown, than similarly situated secular businesses. And so the argument is going to play out in the courts along this line. There's going to be an inquiry of whether this is really discriminatory. And it seems to be that it is, although it's not as a slam dunk as it was in New York, which singled out churches for harsh treatment. But then the analysis is going to proceed into whether the state has narrowly tailored, is the legal language, the punishment or the remedy shutdown to the harm. And it looks like in this case the answer is no. The Archdiocese of Lansing and the Archdiocese of Detroit, which oversee their Catholic schools, have reported transmission rates really low, 1.6%, 1.1%. These are really low transmission numbers, and students are the lowest risk population for significant harm from COVID. So it seems to me that the remedy imposed by Governor Whitmer in shutting down these schools is much harsher than is necessary, and that probably bodes well for this lawsuit.
Yeah, the director of Michigan Association of Non-Public Schools, who is filing this lawsuit, they're making the argument, and the center of it is really cruxed around religious liberty. They say that the state's latest order inhibits the faith formation of students and violates their constitutional right to practice religion while leaving open secular businesses where their transmission of COVID is more likely to occur. While faith is integrated into curriculum, physical presence at a faith-based school allows for unique additional opportunities beyond classroom instruction, and it includes physical religious services, participation in the sacraments, and overall Christian community. So obviously they're making a religious freedom argument, but do you think if the court favors them in this case, it's going to open up the discussion on whether or not COVID is so much of a risk that maybe public school districts can open to?
Well, that is a different question, and it is an important one that's going on in other states. California, noticeably, has had similar lawsuits where secular businesses have challenged and in some cases won. And although the standard of review, that is how much a deference the courts give to governments, will be lower when you don't have a fundamental right like religious liberty at issue, courts are taking a harder eye at looking at these restrictions and saying, are they really fixing the problems that are alleged, or are they just overbroad? Are they arbitrary? Are they sort of painting with a broad brush and doing a lot more harm than they are doing good? And that's a good thing.
Yeah. Well, and Governor Whitmer has issued unconstitutional executive orders before declaring states of emergency, and a state court actually ruled later against her, citing that she was using this power without legislative support. So do you think in this case she's doing that again?
You know, I don't know what the authority she has under the state constitution claimed for this particular order. But at the end of the day, what you'll look at for this one is the federal constitution, because it's a First Amendment religious liberty claim. And on that basis, and that's the only basis you'd need if you wanted to invalidate it. And on that claim, this argument, on that issue, this argument is looking relatively strong.
Oh, well, good to hear that. Thank you so much for having the time to take with us today. I appreciate it.
It's my pleasure.